Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another Webinar Wednesday. If this is your first Webinar Wednesday, then an extra special welcome to you. Today we have esteemed elder law and estate planning attorney Robert Mannor, and he's giving this webinar especially for millennials and Gen X'ers who want to learn what legal documents are crucial to protecting yourself, your family, and your future. Before I pass the torch to Bob, I'd like to cover just a few housekeeping details. First, a disclaimer. While the information that you're going to receive on today's webinar is going to be awesome, informative, educational, it's not legal advice. So I do encourage you that if you are looking for specific legal advice for your unique situation, to contact us after the webinar. Next, I'd like to remind you that today's webinar is recorded. So, most likely you're tuning in from home. If the dogs start barking or, a neighbor walks by and you want to wave from the window, don't worry, today's webinar is recorded. I'll send out a replay later this week. And you can also share that replay with family and friends. Another reminder, if you have questions at all during today's webinar, please put them in the chat box. We will review questions at the end of the webinar. And if we have a ton of questions and we just can't get to them in time, we will contact you after the webinar to answer your questions. Now, why should you listen to the folks at Mannor Law Group and what we have to say? So first, I'd like you to know that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are, in fact, accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He is one of only 19 attorneys in Michigan to achieve this designation. Right now, he's on the executive board of the State Bar of Michigan Elder Law and Disability Rights section and past president of the National Academy of Elder Law Attorneys Michigan chapter. Lastly, we're very proud here at Mannor Law Group to have been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Without further ado, I'd like to welcome Attorney Bob Mannor.
All right, so we're going to go ahead and get started here. I will share. All right, there we go. So let's get right into this. This is the agenda for today. Just kind of covered a few things. A lot of times we're often thinking about our parents and making sure we have, that they have proper legal planning in place. But this one is specifically for the folks that are a little bit younger. And there's going to be a few, obviously, differences between the different generations, what I call Gen X and the Millennials. But there's going to be a lot of things that are going to be similar, where many of us have not gotten to the point where we felt it was necessary to really have a thorough legal plan. Now, with everything going on right now, it seems maybe it's more front of mind that we should be making sure we have our ducks in a row, but it is often something that we put off until a later date, or maybe we did something right when our kids were born, but it's not really sufficient or it's out of date. So the topics are why good legal planning is going to be more important than ever. It's not your parents' estate planning. We're going to talk about what some of the differences would be there. Legal documents you need for life. Now, this is actually what I think is probably the most important for our discussion today, because many of us probably think about, oh, well, I have a will, or I have, I've done some legal planning. Well, that's fine, but, most people kind of think about the estate planning as being when you die, right? And is more important than that, especially for younger folks. And by younger folks, I mean anybody under about 70. We have to plan for our lifetime process. And so we're going to talk about some really crucial legal documents you should have in place for now, for lifetime. And of course, we got to talk about what happens after you die. So, but what if you're a parent? Are there some specific legal things that you need to be thinking about and planning for those that have children, whether they're young children or adult children? And we're going to talk about both of those situations and some of the necessary legal planning. And then, of course, death. We will talk about death. What if you die? What if your spouse dies? What are the things that we got to have in place for that? And then we're going to give you an opportunity to follow up on this. So let's start off. Savannah did mention this disclaimer. Basically, what we're saying is you can't really rely on this as legal advice. This is general information. This is education. It's not necessarily going to apply specifically to your needs, and so we've got to make sure that you get specific legal planning for what you need. Why good legal planning is more important than ever? Well, okay, look, I know a lot of folks are going to be in the position where they're saying, okay, well, yes, I can understand when my parents need this, and I just assume everything will work out, everything's going to be automatic, and it's not. There's actually some very specific things, and it's not hard to do, to make sure that you've got things in place, whether things are going well or not going well, in a crisis situation, a pandemic situation, or even on everyday terms, because there's a lot of times our spouse might be able to do some planning for us. They might be able to make some decisions or even sign our name on checks and things like that. But we got to make sure that there is things in place so that you're flexible and adaptable to whatever life direction goes to. So obviously, if you have a family, if you have kids, it's even more important to make sure that we're going to have protections for your spouse, for your kids, that we've got things in place for them. So let's get right into it. It's not your parents' estate planning. The rules have changed. This is not something, on a couple of different levels, it's not your parents' estate planning. On one thing is, yes, the laws have changed. Things have gotten a little bit more complicated. Even for healthcare decisions, it's not automatic that the spouse would be able to make decisions for the spouse, or the kids would be able to make decisions for the parent, especially when it comes to things like life support and those types of things. So the rules have changed over time. There's a lot more expectation that things are written down in the proper way and that they're following the proper process. But the rules have also changed from the standpoint of we don't necessarily, sometimes our parents or the previous generations might have said, okay, well, we're just going to put kids' names on accounts. So we're going to use beneficiary designations for everything, or we're going to have this deed that we signed, but we put it in the drawer and we won't file it until after we die. Those are outdated ideas. And so when I say it's not your parents' planning, your parents shouldn't be doing that either. Those are not the best answers for these types of things, but the idea is there's reasons why some of the old ways are not going to work and not going to be ideal for us. Okay, it's not about what happens if you die. It is okay. It's a little bit about what happens if you die. We got to talk about that. I promise we will talk about that. But the bigger issue is, what if you were sick? What if you were confined to the hospital? What if you're quarantined? How can we make sure that the people you care about and the people you trust have the ability to do things without having to run off into court? And we really don't want to be going into court right now. Most of the courts are closed except for emergencies. It's going to be a backlog because a lot of people don't have these legal documents in place. And if you aren't able to make those decisions for each other, for where you've got appropriate people making decisions, substitute decision making. If you're not, might not be because you couldn't physically, might not be because you are unconscious. It might not be because you don't have the mental capability. It might be that you don't have the physical ability to do it, that you're confined, that you're quarantined, or that you are sick, or that you are unconscious, or you're any of these things. And so it's really important that we have decision making in place. And you can't just, I know a lot of times I've talked to people and we've been in a conversation and they talk about their children and they say, well, yeah, I asked my sister that if something happened to us, that my sister would raise our kids. And I was like, okay, great. That's, I'm glad that you had that conversation. So what have you done? What'd you do next? Well, I asked them and they said yes. And so that's the end of it, right? No, it doesn't work that way. It doesn't work that way at all. That has no legal bearing whatsoever. And so we've got to make sure that there's things in place regardless whether you live or die. And I think actually the lifetime documents are more important. We're going to sort of divide this up a little bit and talk about what are those lifetime documents. And what are the lifetime planning that you need to have in place. It is all about flexibility and options. A lot of people kind of assume that you go to a lawyer once, maybe every 20 years or so, you get some legal documents done, you put them on the shelf, and forget about them, let them gather dust, put them in a safety deposit box somewhere, which they really don't need to be in a safety deposit box, and don't think about it again for another 20 years or until somebody dies or something like that. That's not the idea here. You want it to be where you can accomplish your goals and have that flexibility to make sure that your spouse would be able to access your accounts, to access your retirement account, your IRAs, your 401k, those types of things. That if in an emergency that they'd be able to mortgage the house or sell the house. Well, guess what? You can't do that unless you have proper legal documents or a court order. So it is about making sure that you have that flexibility and the options to be prepared for whatever happens next, whatever happens tomorrow. And it could be, certainly this is as good a time as any to be thinking about these things. But even when this whole virus thing is over, we're still going to end up having lots of need to make sure that no matter what happens tomorrow, that we've got a plan in place, we've got the legal basis for that, and we're going to go through all those documents, which are really important, and talk about how to get those documents. So it is not automatic, and it's not a do-it-yourself project. And so a lot of people think different things. They figure, well, if a spouse dies, if my spouse dies, I just automatically get everything. Well, maybe, but it depends on how things are arranged, and it is not automatic. Or that if parents pass away, that there's a process where they just automatically have an inheritance. And we're going to talk about there's the longer, more drawn out process, and then there's the quicker process where you've actually planned ahead and made it easier for your family. But or things like, my spouse can make decisions for me for medical decisions. Well, that's not really true anymore. Many of you may not remember there was a high-profile case back many years ago, the Terry Schiavo case. In the Terry Schiavo case, it was the husband versus the parents, and there's a whole lot of details in there. But the bottom line is there was reasons why no one was able to make decisions, and the courts really had trouble because of the circumstances with regard to the husband and the circumstances with regard to the parents. And so it's not automatic that a spouse would be able to make decisions for you. It's certainly not automatic that parents would be able to make decisions for their children, especially if they're over 18. So this is not a do-it-yourself project. It does really actually require some real planning. So let's now get into the specifics here. So that was all kind of just a lead up to get into the specifics of the legal documents. What documents do you need for life? Okay, so these are your lifetime documents. And in my mind, these are more important than whether you have a will or not. So most people, they think, oh, well, I've got kids, I got a will, or, if they're older, whatever the situation, they say, okay, I've got a will in place. Well, honestly, that's great, but it's not going to help you during lifetime. And I think the lifetime documents are much more important. As we've seen from the unexpected, anything can happen. And so if I'm incapacitated in any way, physically, mentally, unconscious, dementia is obviously something as we get older. Any of those things where I'm not able to completely participate in whatever it is that needs to be done, or even just from a standpoint of convenience. If I want my spouse to be able to go to the bank for me, if I want my spouse to be able to make phone calls for me, things like that, from a matter of convenience, we need to have these lifetime documents in place. And so the most critical ones are going to be either your patient advocate or your healthcare power of attorney, and then a financial power of attorney. Now, notice those are separate tabs here. They're separate documents. Many people see the word power of attorney and they think, okay, well, that's great. Now that's going to cover medical, it's going to cover the bank, it's going to cover the finances, the life insurance, whatever it is. It doesn't. It does not. There actually are two separate documents. And in Michigan, they're required to be two separate documents. The reason is they have different standards for when they're used or when they are activated. And so a patient advocate has one standard, a healthcare power of attorney has one standard, whereas a financial power of attorney has a different standard. And so they really need to be different documents, and they accomplish different things, and the law treats them differently. So there's not a one-size-fits-all. I see them occasionally. Sometimes they're older documents. Sometimes somebody just, had a form that tried to have both documents together. Sometimes it was bad advice from somebody that should have known better, like a lawyer or somebody else, some other professional. But the reality is in Michigan, these are two separate documents, and they need to be two separate documents. And often we want different people for those things. So the first one is the healthcare power of attorney or patient advocate. It is not a one-size-fits-all document. This is not a fill in the blank form. You really should have some discussion about it, think it through. Issues such as, under what circumstances would I want to discontinue life support? Under what circumstances? Well, obviously, if you're capable of saying what you want, if you're conscious and mentally capable, then you say what you want as far as life support. That's always the case. And that's always the case even if you have one of these documents in place, especially, if the document only takes effect if you're not able to say what you want. That's the rules. You cannot appoint somebody else to make life decisions and health decisions for you unless you are incapable of doing it. So obviously you have to do that prior to becoming incapable of doing it. And so one of the big things is having that conversation about, okay, under what circumstances would I want them to discontinue treatment? Is hydration and nutrition treatment? Is food and water treatment? Sometimes it is if we need artificial delivery of food and water, like a feeding tube or, hydration. And so the idea is these are all things that can get complicated and really require some conversation here. And under what circumstances would you want your spouse or other loved ones, whoever it is that you're appointing, to be able to make that decision for you or at least convey your wishes? Now, in many states, and you probably have heard some of this either by just watching TV or movies or different people in different states, they'll say, you can have a living will. Now, a living will has nothing to do with your last will and testament, and a living will has nothing to do with a living trust. A living will is actually a healthcare document, and it says in some states you're allowed to write out your wishes as it relates to end-of-life issues and life support, and it is enforceable on its face in Florida and other states, where you can just say, under these circumstances, I do not want life support, or under these circumstances, I do, and those types of things. That's not an enforceable document in Michigan. We don't have that in Michigan. What we have in Michigan is you want to lay out those terms and say, under what circumstances you want life support and hydration, nutrition, all of the rest of this, but you also have to appoint somebody to convey your wishes for you, all right? You need somebody who is able to talk to the doctor, able to get a second opinion, able to take into account all of the relevant information that's happening at that time, and then convey your wishes. Okay, so that's really, really important that you know that's not just a document that you sign that just says, I don't want life support. That doesn't work in Michigan, okay? Some states it might, but it doesn't here, okay? So it's very important that we have that. Other things that you got to think about and why this is not a one-size-fits-all document is things like, well, what if the doctors can't agree on treatment? What if one doctor says, boy, I think, we've done everything that we can, and I think we should just let nature take its course. And the other doctor says, no, I think we should do brain surgery, and we're going to, cut you open and just kind of go around in there. But I'm being a little bit frivolous with this, but the idea behind it is, what if the doctors can't agree? How do we resolve that? Do you want to have the doctors have a bigger say in it, or do you want to have the family have a bigger say in it? That's a real important thing that we've got to distinguish and specify who has the final decision-making authority. If it's not, is it the doctors or is it the family? Another big one that is probably one of the harder decisions for folks, especially for folks with adult children, and is what if my kids can't agree? If I've got one child that says absolutely not, we need to do all kinds of life support, and another child says this is what mom wanted or this is what dad wanted, so they get to overrule it. How do we deal with that dispute between family members or disagreement? Now, ideally, we can make it so we get everybody together, we get their questions answered, we make sure that can be done as a family, but we got to resolve that in the legal document. It's got to say, first of all, an order of people as far as who's the person that's going to convey these wishes for you, and then secondly is, well, but what if there's disagreement? What if my spouse disagrees with my kids? What if my kids disagree with each other? Do my parents have any say in this? These are all things that we've got to think about, and we've got to include in that legal document. So again, not a one-size-fits-all document. And finally, something that is not in a lot of these documents, but I think is really important to have in these documents, and this one's a little bit more complicated, but what if it gets to the point where you're considered incompetent to make your own decisions for whatever reason? the doctors have determined that you're unable to make decisions, altered mental state, mental health issues. There could be a number of reasons, dementia, right? Any reason why the doctors have determined, and it can't just be one doctor, it has to be at least two doctors, have determined that you're not capable of making those decisions because of some altered mental state, mental health issue, dementia, anything like that. Can your family authorize treatment against your will? And the general answer is no. Even if you've been declared incompetent, the general answer is no. They can't authorize mental health treatment against your will, even with a regular patient advocate or a regular healthcare power of attorney. So we put some language in our documents that deals with that issue too, and that's a real tough one. And we kind of walk you through it and say, okay, what's the issue here? Do we want to have, if you've been declared incompetent or declared unable to make decisions for yourself, what level of authority do we want to give your spouse or your kids or your brother or sister or parents or whoever it is to be able to make those decisions? This is really important. We're going to talk in a minute about if you do have kids, especially kids that are over 18, have they given you that authority? Because if they're over 18, you have zero authority with regard to healthcare, even getting information, getting any documents, getting a report. They could be in the hospital, and the hospital, under the HIPAA rules, are not supposed to even, tell you that they're there, let alone what the treatment is or why they're there or anything like that. So do we have that language in there that says, okay, well, what if I'm declared incompetent and I'm refusing treatment? Can we still make sure I get the treatment that we need that might, help the situation, whether it's, medication for mental health issues or whether it's even a simple antibiotic. One of the things we see with our older clients often is when somebody's older and maybe they have a little bit of dementia or memory issues, and then they get a urinary tract infection or some kind of body infection, and all of a sudden their dementia spikes and goes through the roof, and they are talking gibberish and not knowing, and it just seems like overnight they got Alzheimer's or dementia or something like that. Typically in that situation, it's because there's some kind of body infection, or maybe it's a medication they're taking that they used to maybe take, and now it's causing this reaction. And so we need to be able to have that ability to even just make sure that antibiotics are administered if it's a urinary tract infection or something like that. But if you're refusing to take that antibiotic, we want to make sure, if you're incompetent, we would want to make sure that you can get that so that your mind can clear up and things like that. So that's the healthcare one. Separate document would be the financial one. And so unlike the healthcare one, I actually recommend that your financial one is effective immediately. So a lot of people and even a lot of lawyers will say, oh, well, we don't want anybody to have your power of attorney for financial matters because then they could go down to the bank and write a check for you. Exactly. And that's why I want it to be effective immediately because honestly, if you do not trust that person to be able to go down to the bank today and write a check for you, then you picked the wrong person. And if you don't have anybody that you would trust with that authority, then you shouldn't have a financial power of attorney, and we should just rely on the courts if and when that's necessary. And I'm very serious about that. When you really think about this, if you don't trust them when you can watch them, then how can we trust them after you've been declared incompetent or incapacitated? So we really want to make sure you have the right person. My old law school professor used to call these license to steal, right? A license to steal. Now, if I give somebody a license to steal, is that a bad thing? No, it's a good thing because I would only give it to somebody who wouldn't steal, right? Now, can they go to jail? Could they get in trouble for using that inappropriately? Absolutely. If you have your parents' power of attorney and you use it to take the money out and spend it on yourself or anything else, you can go to jail for that. Absolutely. The point is money's already gone, right? The point is that the bank will seize that power of attorney. They're supposed to accept it, right? They're supposed to accept it and says, okay, well, daughter is power of attorney. It says that she wants to withdraw $10,000. They are supposed to accept that. And there's issues and conversations going on about when banks should accept that and when banks should, kind of double check or call and protect their customers and things like that. But the bottom line is once the money's out of there, it's potentially gone. And so, yes, you could go to jail for misusing a power of attorney. It's just that nobody's often, in theory, nobody's going to stop you from using that for bad intentions. So you just have to make sure we got the right people in place. Do you want your spouse to have that authority? Do you want, if your kids are adults, are they ready for that authority? And sometimes if they're 18, they're not ready for that authority, right? And so you really want to think about that. And sometimes when our kids are younger, we're going to want, obviously they have to be 18 before we could give them any authority. But if they are 18, they still probably, most kids that are 18 aren't going to be suitable for that. So we'd still maybe use our parents or our brother or sister or, whoever it is that we feel comfortable with. But it is real important if you have people that you trust and don't think that they would ever take advantage of that we have that in place, even between husband and wife, right? So a lot of people think, oh, I don't have to worry about this because I'm married. Well, wait, I think you do. Here's why. There's many accounts that are not joint accounts. You might think of them as joint accounts. What's mine is hers, what's hers is mine. You might think of it that way, but legally it's not. And particularly, I'll give you some examples. An IRA, a Roth, 401k, a 503b, any of these things, 503b, that might not be a right one, but any of those retirement accounts where whether you paid the taxes on it or not, so even a Roth, they are individual accounts. They're tied to one person's social security number, right? And so they are not supposed to allow the spouse to call up and take a withdrawal out of there. So if you became incapacitated, what are we going to do? Well, hopefully we have one of these financial powers of attorney in place. Otherwise, we're going to have to go and get a court order. Okay, so that's really important. The second thing is, what about your house? So you say, well, both our names are on the house. That should be fine. Well, no, not necessarily. What if you want to refinance your mortgage? What if you want to sell the house and downsize or buy a new house or whatever it is? The idea is if both spouses are on the deed, you need two signatures. And, well, your spouse might sometimes forge your signature, and with permission, that's actually okay. Not forge, but it's okay to give somebody permission to sign for you. That is actually a legal thing. You can verbally give permission for that. But they're not going to allow that in a mortgage signing, right? They're not going to allow that in a closing on a deed. So we either have to have a power of attorney in place or we need to get a court order. And so if you became incapacitated, your spouse becomes incapacitated, that's going to be a real issue and real important. The trust. So a lot of people think about a trust. Sometimes they call it a revocable living trust. So revocable, a trust is just a contract between you and the people you love, right? You and your family, typically, you and your spouse, you and your kids. It's you and whoever you want involved in your things. And so the idea of the trust is that it's a contract that says, here's how I want things managed when I'm alive and well. Well, what's the rule there? If you're alive and well, you get to do whatever you darn well please, right? No restrictions on what you can do when you're alive and well. What you can do or what can be done if you're incapacitated. Okay, that's the rule number 2 that's going to be in the trust. If I become incapacitated, who's in charge and what are they allowed to do with my stuff, my money, my house, everything, right? And then the final rule, of course, is what can be done and who's in charge after I die. And that's what a trust is. It's in theory, it's not that complicated. Now, the idea is you get to write your own rules and your own contract, which is why it's different than a will. And I'll go through these types of things in a minute, but why is it a lifetime document? Well, what we find is, first of all, in the event of incapacity, the trust is going to be a lot easier to manage rather than going around to each and every single asset that you have. All right, I got to go to Fidelity for this and MetLife for this and the credit union for this and the bank for this. We have one set of rules that manages everything, and that makes life a lot easier when we're dealing with incapacity. It certainly makes things a lot easier if you ever get to that point where, because of age or because of illness or whatever, somebody else has to step in and do things for you. So the trust is a much more manageable and easier to use than a financial power of attorney. And I'll explain that in a couple minutes when we get to the trust. And then HIPAA. So many of us are familiar with HIPAA, the healthcare privacy law. I don't know, 13, 14 years ago, they passed all these HIPAA rules. You can't share medical information with people without having that HIPAA waived. And you can waive it for specific people. Now, under one of the executive orders, some of the HIPAA rules actually have been relaxed. under the current situation with the pandemic, and so that's okay. But some of the in a normal time, we need to be able to have those HIPAA waivers and identify who would be able to have access. Plus, HIPAA's been kind of applied to everything. So even things that we wouldn't think of as being a medical issue, people are still saying, well, I can't give you that information because of HIPAA, like bank statements or beneficiaries on an account or beneficiaries on a life insurance. And the companies are often saying, well, we can't give out that information because of HIPAA. And so it's really important that if you want people to be able to get access to things, that we have a separate HIPAA waiver for that. All right. We're going to shift gears and then come back to that will and trust and all of those things in just a minute here. But what about if you're a parent? So you got kids. One of the things often lots of folks do is you're going to be away for the weekend, just the parents or parent or a single parent, and you're leaving the kids with your sister, or you're leaving your kids with your parents or whatever. And so a lot of us would just kind of write a note, and we write it out and we say, okay, here's the Blue Cross card, and I'm just going to write a note saying that my sister has the ability to make decisions. Is that legal? I hope that they would honor that. There's actually a specific legal process. There's called a parental power of attorney that you can designate and specifically, legally, and effectively give someone else temporary authority to make healthcare decisions for your children and make other legal decisions for your children. It is the parental power of attorney is defined by time period. So you say, well, I'm going to be gone from the 15th to the 30th. Then you can have that. And so it's one of those things that it's not going to be an ongoing thing necessarily. It's going to be a time-defined document. And so then every time you go away, you just sign one of these documents with the new dates on there, giving whoever it is that you're leaving your children with that authority to admit them to the hospital and make medical decisions, whatever. Now, obviously, things can be done over the phone and over the internet and video calls and everything else. But a lot of us would like to have that extra protection, especially if we're going overseas or something like that, extra protection that whoever we're leaving our kids with has that legal authority. So it's a real simple document. We can help you with that, and it's a real easy thing. If your kids are over 18 years old, what legal planning should they have? And so this is really a big thing to think about. So the second they turn 18, you have no control. Not that you had a lot of control before that, but you have no control because you can't even get access to information. If they're in school, if they're in college, if there's a healthcare issue, if they're admitted to the hospital, you can't get access to that. You can't make decisions. You can't get access. If they're incapacitated, you got to go to court and get somebody appointed, by the court, which could be you, but you still have to go through that court process. And so the idea is pretty much anybody over 18, if they've got a good relationship with their parents, pretty much on their 18th birthday, I know this is probably not going to be something they're going to be real fond of, but for their 18th birthday, a great present, they're not going to think so, a great present would be to have them sit down with a lawyer and get a healthcare document and a financial document. So in the event that something happens, and until they have something else that, they're off and they've got a partner or whatever it is, or a little bit older or whatever, maybe appointing the parents as financial power of attorney and healthcare power of attorney, and certainly HIPAA waiver. We want to waive HIPAA for parents, assuming you have the relationship that we'd want for that. But it's real important. I do recommend anybody over 18 have those three basic documents: HIPAA waiver, healthcare document for substitute decision making, and then a financial power of attorney. Financial power of attorney is probably maybe a little bit less important for the 18-year-old, but certainly the HIPAA and the healthcare patient advocate power of attorney would be real important. Who would raise your children if you're gone? Okay, so if you die, if their other parent dies, things like that, who would raise the children? Well, a lot of us, I talked about this earlier, we might have just said, okay, well, I talked to my sister about that, and she's okay with it. She said yes, so that's all we need to know. It doesn't work that way, okay? The only legal way to actually specify who's going to raise your children if you're gone is through your will. We have to put that in a will document, okay? So regardless of any other documents, power of attorney, parental power of attorney, trust, anything else, we've got to put that language in the will. That's the only legally binding document that's going to specify who's going to raise the kids. Now, the next question is on there too, like who should handle the money? So maybe you have some life insurance, you have a house. Are we ready to have, first of all, if they're under 18, guess what's going to happen? The court is going to appoint somebody to manage those assets. So if they inherit assets and they're under 18, they're a beneficiary on a life insurance and they're under 18, they can't. That's legally not allowed. And so the court is going to appoint somebody, maybe somebody you don't really want, especially if you're a single person. If you're divorced or you're not married to their parents, guess who's going to be in charge of that life insurance that you left for your kids? It's going to be their other parent. That's likely. I can't guarantee that, but the court's often going to say, okay, well, parent, that's who's raising the kid is the other parent, perhaps. And so we're going to put them in charge of the money too. And often a lot of folks would say, I'm not really fond of having my ex-husband or my ex-wife in charge of the life insurance proceeds or in charge of whatever it is. And then the other just as bad is on the 18th birthday, guess what happens? They have full access to it. So if you have a house, guess who, gets to decide on the house? Or, if you have more than one kid, a percentage of the house and things like that. Life insurance proceeds. In my expectation, 18-year-olds aren't the best decider of should we spend this $100,000 life insurance policy on college, or should we get that really cool car over there, or go on this really cool vacation, or buy our, have this great party that all, we're gonna, whatever it is. Bottom line is, that's the default. The default is, first of all, if you don't have something in place for the kids on the money part of it, the court's going to appoint somebody until they turn 18, and then the second they turn 18, then they have full access and full control, and they can do whatever they want. So we don't want either of those things. So even a simple will is not enough in this situation. We can handle this we must handle this through the will from the standpoint of who's going to raise the kids, who's going to be the guardian of the children, who's going to make legal decisions for them. And whether we want that to be the same person who'd be in charge of the money or a different person. Sometimes we want that to be a different person, than who would be raising them. Sometimes we don't. Sometimes we want your sister to be both, the person in charge of the money, something to think about though, because, there's not really going to be anybody overlooking them that carefully as far as what's happening with that money. So the idea is sometimes we have a different person for who raises them and who manages the money. But my point on here is even a simple will is not enough when it comes to this. Why is a simple will not enough? Well, if a simple will just says, I've read this provision thousands and thousands of times, it basically just says, when I die, everything goes equally to my kids. And often throw in a Latin word or two. That's not the exact wording of most wills. But the bottom line is your kid's under 18, that's going to create a problem. Or if your kid's 18, that's going to create a problem too, because now they have full access and control. So in the will, we need to have some provision. So in the will, we actually have to have a trust, which is funny because, people think a will versus a trust. A will can actually include a trust and should in a situation like this if you've got younger children, certainly if they're under 18, but even if they're 18. So at what point do we trust them with the $100,000 life insurance policy or their percentage of the house or, whatever? Is it 18? Is it 21? Is it 25? Is it 65? I don't know. The bottom line is it is one of those things that we have to think about. These are all things. This is why form documents are not appropriate. This is why fill in the blank stuff is not appropriate. The people at Mannor Law Group have been thinking about this. I don't know. We probably have. I don't know if I added up all our years of experience, but I know I've been thinking about it for 25 years now. And we think about all the nuances. And when you don't think about some of the nuances and really have real thorough planning, things can go very badly. And we hear about these stories all the time. And so I was saying recently that people were asking about those online companies where you can get a will drafted online, or you can, get a form and fill it out or whatever. And my answer is I've made a lot of money through the years fixing those. And when it doesn't mean, the question is whether they're enforceable or not. Yes. often to your detriment. In other words, almost to a time when I've looked at those documents, they were wrong. And by wrong, I don't mean that they were not legally enforceable. What I mean by wrong is they did not accomplish the goals of the person that was signing the document. When I started asking them questions about, well, what about this? What about this? They would say, no, I don't want that. I don't want that. So it's not about whether the court would enforce that document. It's they're going to enforce it to your detriment because it covers things. It didn't handle things in the way that you expect them to. There's certain defaults in the law that if you don't work around it or draft around it or write around it, and one of those things is like the having the money go to somebody at 18 or having it go to a conservator if they're under 18. And so bottom line is what we do in this situation is it can still go through the will, but the will then set it up so that it says this person's going to be in charge of the money until they turn 25, until they turn 21, 27, 28, whatever it is. You get to decide on the age. And that requires some kind of back and forth too. And that requires some details. You can't just say, oh, I'm going to have my sister be in charge of the money until they turn 25. You can't just say it that way. We got to have details. You have to have, the contract laid out to say what specific authority they have and give them specific authority. People will often complain about the number of pages legal documents are, and they complain about lawyers and how wordy we are. Well, there's a reason for it, right? We have to be detailed. We have to think about everything. We have to cover every possible contingency. If anybody has looked at their parents' documents, or if you have these documents and you look at the difference between a will and a trust, a will is often a very simple, just a few pages. And so a lot of people say, oh, I like that. That's simple. Well, but it has complicated results. Okay, whereas the trust might look more complicated because it might be 60 pages, but it has simpler results. What are we going for? I know we want simple, right? I get that. I want simple too. But do we want it to be simple to look at? Or do we want it to be simple to administer, right? Or easier, more efficient, more convenient to make that work, okay? So what if we die? And so we're going to go through these different documents and kind of lay these out for you. The first one, we tend to do things, if you give us a call, you'll notice that if you just say, hey, I want a power of attorney, we're going to say, okay, great. We'll get you some information here about this, and we'll have you come in and we'll talk to you. Now it's virtual meetings, so not necessarily come in, but we'll talk to you in a virtual meeting. And the thing is that we'll also say, okay, but we're going to also talk to you about, healthcare. We're going to talk to you about what if you get sick, and we're going to talk to you about wills and trusts. We're going to talk about all these other things. We're going to talk about your finances. We need to know about, you can't diagnose, you wouldn't expect to go to the doctor and say, something is wrong with me and I want this prescription. And the doctor's going to be, okay, I got to do some tests. I got to ask you some questions. If we find out other things are wrong with you, we need to do an analysis, right? We need to do that as lawyers. We need to know about your finances. We need to know about dollars, specific amounts, okay? Our advice can be different if there's $1,000 versus $100,000, okay? Our advice is going to be different if it's an IRA versus a mutual fund. Our advice is going to be different if you have more than one piece of real estate, or you have real estate in different states and things like that. Our advice is going to be different if you have more than one kid. It's going to be different depending on your circumstances. And so, again, one size fits all stuff doesn't work. So what I'm getting at here is we do things in packages. In other words, somebody's going to leave with just one random ad hoc document. If you say, all I want is a power of attorney. And if you insist on that and don't let us ask our questions and then just at least ask you about all the rest of it, we're going to say you should probably just find another attorney, because we don't do that. We're going to do thorough planning, and we're going to make sure not everybody's going to have a trust, not everybody's going to have this or that, not everybody even needs a will sometimes, but at least we're going to make sure that we're comprehensive, right? So that I was able to have a virtual meeting with my clients last week, and a lot of them were on there and they were worried. And I said, you know what? I know if you're my client that we've got those minimums taken care of. If you're my client, you didn't leave my office without having the basic minimums taken care of that's going to be able to deal with this coronavirus stuff. And I can say that confidently because we don't do ad hoc planning. We don't do piecemeal planning. You're going to get a comprehensive plan. Now, you can decide whether we want it to be a will-based plan or a trust-based plan or things like that. So the first thing we're going to talk about is this will-based plan. So with the will-based plan, I like to think about the will as like a funnel. And I call the will a funnel because it funnels things from mom and dad down to the kids, or from, whoever died down to whoever, is supposed to get it. And it's a catch-all. So it will catch anything that needs to be caught. And it only catches those things that are only in your name when you pass away. So it doesn't catch things that have beneficiary designations. It doesn't catch things that have joint owners. Well, we might want to use beneficiary designations, and that's part of the thing that we'll talk about when you come in. But we definitely don't want to add your kids' names to your accounts. You might have husband and wife or spouses as joint, but you definitely don't want to add your kids' names to accounts or the house or anything like that. That's a really, really, really bad idea. Okay. So the thing that people don't like about the funnel, though, is it does have to go through probate. A will, if we have to look at a will to see where something goes, it goes through probate. Some people say, well, my mom had a will and it didn't go through probate, so I don't believe you. Well, okay. Then your mom didn't need the will. She might have had a will, but it was not the effective document that transferred the assets. If that's the case, mom had a will and it didn't go through probate, then mom had put people's names on accounts, or she used beneficiaries, or did all this piecemeal planning, right? That's the way that works. The will has no legal effect until it goes through a full probate. And it's going to be a minimum of 5 months to get through probate, typically around a year to get through that probate process, okay? In addition to that, of course, we're going to want to get those healthcare documents in place, power of attorney. We have in our power of attorney something called extraordinary powers, and this isn't right for everybody, but it's something that we have a conversation with you about. Again, why we don't use just form documents. Extraordinary powers is, well, what if, God forbid, something really terrible happens and I have a need for long-term care. I helped somebody years ago. They were in their 50s, early 50s, and they fell down the stairs and became very injured, and were going to need nursing home for the rest of their life, and they weren't terminal. And so they were in their 50s, and they're still alive. It's been probably 10 years already, and they're going to be in nursing home for the rest of their life. Well, how are we going to afford that? How are we going to afford that without impoverishing our spouse, without losing everything? Well, there's a way to do that. That's one of the things that we do. We help people with that. Somebody needs some kind of long-term care in the home, and assisted living, in a nursing home. There's government benefits out there that can help with that, but most of them are need-based. And so we've got to make sure that we can protect assets in favor of the spouse. Well, we can't do that unless you've given your spouse permission, or given your sister permission, or given your kids permission. And that's what these extraordinary powers are. It's the ability to deal with a long-term care crisis to say, how can we protect assets? Now, we're not protecting them by putting these powers in there. We're just saying, I'm authorizing my wife, I'm authorizing my husband, I'm authorizing my son, my daughter, my brother, I'm authorizing whoever it is I put in here to be able to come back and do some asset protection at a later date. And that's not in most people's powers of attorney. And you can't do it if you don't have it, even between husband and wife, right? Even between husband and wife. If a wife were to transfer the house, so let's say husband goes into a nursing home and the wife wants to transfer the house out of husband's name because he's in a nursing home into her name. The state would say that's a gift transaction and would not be allowed under a standard power of attorney. So we have to have additional language in there to be able to deal with if there was that kind of crisis. All right. The next one that we have is our probate avoidance one. So most of the people that are considered in the Gen X millennial age are going to either pick a will package or a probate avoidance package. And the probate avoidance package is where we have a revocable living trust. And remember, that's just a contract you have between you and your family about what you want to have done when you're alive and well, if you get incapacitated, and after you die. Now, the difference between a funnel, the will, and a trust, which I like to call a wagon, is the wagon or the trust doesn't catch anything. So the reason how the funnel works is because it catches the assets that need to be caught and funnels them in the right direction. With the trust, you actually have to retitle your assets. So it's something that requires some maintenance, requires some ongoing. We have this whole process where we help our clients ongoing years and years and years to make sure that the trust is still going to work properly. We don't even charge for that. We just make sure that we're connecting with you, making sure that you have a reminder that you've got to put your stuff in the wagon, is the way we say it. You've got to retitle the house to the name of the trust. We got to retitle the bank account to the name of the trust. We got to list beneficiary designations to the name of the trust. And not every asset's going to be done in exactly the same way. If it's a retirement account, we're going to do it a little bit differently than if it's a non-retirement account. And so this is important. But like I said earlier, not only is the revocable trust, most people, the only reason they do it is they say, well, I just don't want to go to probate. Great, good reason, perfectly good reason. I like the revocable trust also is if you get sick, if you get old. And I say that because if we get old enough, many of us are going to ask for help from our kids. If we're old enough, if you get to 110, there might be a situation where your kids are helping you balance your checkbook by the age 110. That's not going to be, I'm not being discriminatory. It's just a reality of life that at some age, many people are going to require and request assistance, and it's going to be so much easier for them that's trying to help you if it's in a trust. Okay, and so this is the probate avoidance package is going to cost a little bit more in the short term. It's going to save you a ton of money in the long term. Okay, the will package, it doesn't cost quite as much, but it'll cost you more in the long run. So when you're young and healthy and things like that, sometimes people just do the will package. They say, okay, I just want to make sure I have everything in place. Yes, I know it doesn't avoid probate, but I'm not planning on dying. And I say, all right, that makes sense. Well, that's perfectly fine. Other people say, no, I just want to make sure we have a plan in place. This is going to grow and breathe with us. They change it whenever we want. We want to have this in place. We want to do the better planning and make sure that we're going to stay out of probate, make sure we got things in place in case of incapacity and all those other things. Okay, so that's it. I want to go through two other options for you that are just really interesting. And we'll talk to you about it if you come in. One is generational planning, and that's where we say, okay, wouldn't it be great if we can, leave money to the kids and help them make sure they're going to pay less taxes on our retirement accounts, on our IRAs? Can we make sure that it's not going to go to their spouse if they get divorced? Can we make sure that if they have creditors or if they have health issues, that the money I leave them isn't going to be eaten up by their debts or eaten up by their health issues, medical costs or things like that? Certainly don't want to lose it in divorce. And so there's what I call generational planning, which we'll explain in greater depth when you come in. It's really can be very interesting. And then finally, we do have this asset protection. And this is for folks that are worried about, what if I need home care? What if I need a nursing home? What if I need assisted living? And there's different types of benefits out there that we can look at and set up the planning in a way that we can protect things. Now, we can do that both in a crisis or we can do it in advance. And if we do it in advance, we can protect more often. In a crisis, we still can do it. Ideally, we have one of those powers of attorney that has those extraordinary powers that I mentioned in it. If we don't, we sometimes have to go into court and ask the judge for permission to do it. So those are the other options there. Savannah, I don't know if we've gotten any questions during this time period, but if you're on the line, we'll take any questions right now.
So far, I don't see any questions. So definitely, if you're here and you're just wondering anything about Bob has talked about today, please feel free to put it in the chat.
Well, I want to go through a couple other real quick things. Obviously, we're all going through some stuff right now with this coronavirus pandemic. And so it is now more important than ever to get these things in place. God forbid if we got sick, we need to have those healthcare documents in place. We need to have if we're married, to have our spouse have the ability to do what's necessary. And I'm hoping that some of the things we talked about today, it made it clear that that doesn't just mean documents. That good legal planning isn't just fill in the blank documents. It doesn't work that way. Like I said, we've made a lot of money through the years fixing the problems that people created by downloading a document and filling in the forms, or following all the instructions properly. They went to LegalZoom or someplace like that and got the document, filled out all the documents properly, and it did not accomplish their goals, and actually often cost them more time and money and inconvenience, and sometimes worse. Sometimes actually got really bad results as a result of it. Your health, your life, protecting your spouse, protecting your family. It's worth it. It's worth it to put a little time into this. I know a lot of us are do-it-yourselfers. This isn't a do-it-yourself project. You may or may not like that, but it is what it is. There's too much here at stake to just try to figure, okay, well, I'll just Google it. No, it doesn't work that way. The laws are different everywhere, and so You Google a form or something like that, it's not gonna be the right answer for you. We need to be prepared for the unexpected. We definitely at this point do not want to end up in the courts for medical decisions, for guardianship, for financial decisions after a death. The courts are going to be overwhelmed if anything happens the way some of the predictions that they're happening. They're going to be overwhelmed anyway because they're currently closed except for emergencies, and they're going to be really overwhelmed if everybody ends up in court. So it's really important that we get this stuff taken care of. So what should you do now? Savannah's going to kind of go through some options. She's going to send you an email in a few minutes, but one of the big things is she's going to go through some options about contacting us. And so we're still fully operational. We're complying with the stay-at-home order, so we're all working remotely. If we're all doing that, everybody knows about that. But we've been able to accommodate that, and we can still do all the things that we need to do and still help you out in whatever way you need help, and make sure that we got you covered. Okay. So Savannah's going to go through some options for you for setting up an appointment. Sometimes the best thing is just sort of a free kind of 15-minute check-in. And that's what we actually prefer, is we just do this free 15-minute check-in. The idea is we're going to want to know a little bit about you, and so that we know, well, what is the issues that we need to be prepared for when you meet with the attorney? Which attorney do you need to meet with? As Savannah went through, there's a number of attorneys here. We have different attorneys that do different things. And so which people in the office do you need to meet with? So we like that 15-minute triage, that 15-minute, just kind of investigation. So it gives you an opportunity to see whether or not you want to follow through with us. And secondly, it gives us an opportunity to make sure that we're prepared for that meeting. And if you're up for it, if you're willing, we have a form that we can send you before that 15-minute meeting, ask you about your finances, ask you about any existing legal documents, things like that. We'd really like you to fill that out before the 15-minute meeting. It's not required. You can have the 15-minute meeting and kind of interview us a little bit to see whether or not you want to take the next step. But at least before the meeting with the attorney, we're going to need you to fill out that questionnaire. Otherwise, you're just not going to get the value that you need to get. So Savannah, if you want to take over and just kind of give some instructions as far as what the next step is, to make sure that if you have legal documents, that we look at them, make sure they're up to date, see if there's any changes or updates that we need to make, and if you don't have legal documents, that you get them.
Yes, thanks so much, Bob. And thank you so much to everyone for joining us today. As Bob mentioned, we do have a couple of easy ways for you to get started working with our team. If you already know, hey, this information was valuable, I'd like to move forward and at least meet with an attorney and see what steps they think I should do. Well, in that case, as Bob mentioned, we'd like you to go ahead and schedule a 15-minute interview or intake appointment with Katie. Katie is our client services director, and she's going to meet with you one-on-one over the phone to just determine which attorney would be the best for you to meet with. And then the other option is if you just kind of have some questions, you're not sure if you need an appointment, then you're definitely welcome to just contact our team. Now, I'm going to be sending you an email shortly after we wrap up today's webinar. In that email, you'll have two options. One option is a button you can click that will actually let you choose your own appointment to meet with Katie. You'll click the link, you'll go to her Calendly account, and you'll be able to choose the best day and time to have that 15-minute phone call. If you're not ready for the appointment, in that same email, you can also click the button, a different button that will let you just contact our team. You can send us a question, and you can let us know what it is you're concerned about and if you think an appointment, or if we think an appointment might be appropriate. Our team will reach out to you within 24 business hours from the time that you send in that contact us question. So again, I'll be sending that email out to you shortly after we wrap up today. And we hope that no matter what, whether or not you choose to schedule your intake call with Katie or contact us with questions, I hope that you know that we are here for you no matter what. So thanks again, Bob. Thanks again for joining us. Stay tuned for that email, and then also stay tuned for your invite to attend next week's Webinar Wednesday. We'll see you then.